Good morning. My name is Gautam Bhatia and I work at the High Court of Delhi. And as part of this module on comparative constitutional law, I will be discussing bills of rights. Bills of rights form the backbone of most modern constitutions, as you are well aware. And so it's important to understand what bills of rights are and why they are present in constitutions before we go on to discuss specific rights such as the right to life or the freedom of expression, the right to equality, and so on. So first, what is a Bill of Rights? A Bill of Rights is premised upon the very basic and simple idea that there are some limits to the coercive power or authority that a sovereign can legitimately exercise upon the individuals subject to his or her jurisdiction, even if that sovereign is a popularly elected government. We've seen that the idea of there being limits or checks upon sovereign power is a very old idea. You see it in ancient Greece, you see it in the medieval republics, and even in the medieval empires. Even as the idea of monarchic absolutism was rising, at the same time there was a pushback and there was a prevalent idea that there are some limits to what sovereigns can do. So famously, thinkers like Thomas Hobbes and John Locke used to argue that certain basic rights are reserved by individuals. Even as they agree to submit to the sovereign, still there are certain rights that the sovereign cannot encroach upon. And the Bill of Rights enters into the picture when the shift in power comes from a monarch or a king to an elected government. And so the idea is that even if power is exercised by an elected government, there are still limits to what that government can do. And so again, in brief, there are limits to how far a majority can legitimately exercise the power that it has won through the ballot box in a democracy. And when these limits are spelled out in the form of rights vested in individuals or citizens, which mark the boundaries of state power, that result is what we call a Bill of Rights. Now, the origins of Bills of Rights actually go far back in history, even before the advent of modern democracy and the Enlightenment. The first variant of a Bill of Rights that we can identify as such is as old as the 13th century, when King John of England was compelled by his barons to sign the Magna Carta, which means the Great Charter. The Magna Carta was a document that circumscribed the boundaries within which the king could act. It placed limits upon the king's power, placed limits upon his power, for example, to confiscate property or to levy taxes. Now, because the Magna Carta was an agreement between King John and his lords and barons, the people as such did not have many rights that were vested by that document. But nonetheless, the very idea that you placed limits upon the power of the king, which are specifically written out in a document, is a precursor to modern day Bills of Rights. And in fact, it is a documented fact that the Magna Carta was what influenced the first proto-modern Bill of Rights, which is the 1689 Bill of Rights in England, which came about after the Glorious Revolution. And when the monarchy was restored, after that, there was again the limits on the monarchy's power were spelled out in a Bill of Rights, and this Bill of Rights actually, for the first time, codifies some of the individual rights that we are very familiar with today. For instance, the freedom and the right to petition the sovereign for the removal of grievances, rights against cruel and unusual punishment, the right to a trial by jury, and so on. So we see it is in 1689 that for the first time a Bill of Rights assumes something like the modern forms that we are familiar with today. As far as that goes, in England there weren't too many developments after that, and it is in the United States that a Bill of Rights first appears in its very familiar form, that is within a written constitution. The idea of a Bill of Rights as placing a check upon the actions of a strong centralized authority was at the forefront of the minds of the framers of the American Constitution. You may recall that the United States was created out of a revolution against the sovereign power in England, Originally, there were 13 colonies, and these 13 colonies rebelled against the King of England and declared independence. And afterwards, there was a debate within the representatives of the 13 colonies about bringing them together into one country, which would be governed by a central constitution. And the debate was between the Federalists and the Anti-Federalists. The Federalists wanted a central power which would make the United States stronger as a whole, whereas the Anti-Federalists were very nervous and worried about the consequences that a strong central power would have upon the rights of individuals. And so the Anti-Federalists made it a condition of agreeing to the Federation that the final constitution would contain a Bill of Rights. And that is how the American Bill of Rights emerged. And you will notice that the American Bill of Rights appears as a set of amendments to the original constitutional text. That is because of the debate between the Federalists and the Anti-Federalists. Now, among other things, the American Bill of Rights guarantees to its citizens various rights that are very familiar today. For example, the freedom of speech and expression, the freedom of religion, the right to bear arms, the freedom from unreasonable searches and seizures, the right against self-incrimination, the right to a jury trial, and so on. And you will notice that many of these rights are actually found within the Indian Constitution as well. So free speech, freedom of religion and conscience, and the right to life and personal liberty are all found in the Indian Constitution, and indeed in most of the constitutions around the world, which only goes to show the formative influence upon modern constitutions and bills of rights that the American experience had. So, and then this is why often we see courts all over the world, including India, referring to American constitutional precedent to better understand the issues that arise when interpreting bills of rights and the scope and limitations of specific rights placed within bills of rights. Now, of course, a Bill of Rights does have all these nicely worded rights against the government, but of course, if there is no power to enforce those rights, then those rights don't have much meaning. In fact, interestingly, when the American debate was happening between the Federalists and the Anti-Federalists, James Madison, who was a prominent Federalist and one of the acclaimed founding fathers of the American Constitution, was very hesitant about including a Bill of Rights, not because he wasn't in love with the idea, but because he simply couldn't understand what the point would be of these rights, which were anyway would be left to the government to adhere to if they wanted to or not. And James Madison famously called bills of rights parchment barriers. He thought that they would not play any constructive role in actually limiting government power, because of course the power ultimately would stem from elections and from the people, and a Bill of Rights would just be a piece of paper that would limit those powers. And that worry was famously put to bed in an American case called Marbury versus Madison, which went up to the Supreme Court. And in Marbury versus Madison, Chief Justice Marshall, one of the most famous constitutional judges of all time, held that the Supreme Court was tasked with interpreting and expounding upon the Constitution. Insofar as the government overstepped its limits, it was the court that had the power and the authority to hold its actions unconstitutional and therefore void and without any legal force. Now, this was a landmark advancement. We now think of a Supreme Court adjudicating upon legislation and holding it unconstitutional as something very standard and very run-of-the-mill. But that hasn't always been the case. And actually, it was Marbury versus Madison that established this principle as a constitutional principle. And originally, in fact, Justice Marshall's opinion led to a great amount of controversy and a great amount of problems, because of course the popularly elected government was very unhappy with the fact that an unelected court would sit in judgment over its legislation and hold it unconstitutional and without any force. It seemed that there was something very wrong in an unelected body deciding upon the actions of an elected parliament. But that, of course, is the entire point of a constitution, and the idea that the constitution is supreme and that every organ of state, including the parliament and the judiciary, is ultimately subordinate to the constitution. And if that is the case, then of course the task of expounding the constitution would rest upon the judiciary. And that is why the principle of Marbury versus Madison survived its inception and has now become one of the most important governing principles of modern day bills of rights. So, to quote from the case, which is again, to repeat, one of the most important cases in constitutional history, Justice Marshall says, "It is emphatically the province expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. So, if a law, for example a statute or treaty, be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law disregarding the Constitution, or conformably to the Constitution disregarding the law, the court must determine which of these conflicting rules governs the case. This is of the very essence of judicial duty. If then the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution and not such ordinary act must govern the case to which they both apply. Those then who controvert the principle that the Constitution is to be considered in court as a paramount law are reduced to the necessity of maintaining that courts must close their eyes on the Constitution and see only the law, for example, the statute or treaty. This doctrine would subvert the very foundation of all written constitutions." Close quotes. So, you see how the basic idea is that if a constitution is to mean anything at all, then the ultimate power to interpret whether or not Parliament's acts conform to it must lie with a body which isn't the Parliament itself. Because if the Parliament was to itself determine whether its own law would conform to the Constitution or not, then really that wouldn't amount to any meaningful limits in the first place, and we wouldn't even need to have written constitutions. In fact, some countries don't. A good example is England. England doesn't have a written constitution and they get along just fine. The idea is, however, that if we have a written constitution, then judicial review becomes an essential sine qua non of that constitution. Now, as we have noticed a little while ago, there seems to be a tension between judicial review and democracy. So, opponents of judicial review argue that the source of legitimate power and authority must be the consent of the people. In a democracy, people consent to their elected representatives acting on their behalf through the procedure of voting. Therefore, these arguments go, it is anti-democratic if the will of the representative of the majority is overridden by an unelected judiciary. That's basically the argument against judicial review. It's been made by important scholars such as Jeremy Waldron, for example, who has written 2 seminal pieces on the issue. On the other hand, supporters of judicial review argue that in a democracy which is ultimately based upon the principle of majoritarianism, which means that the majority gets its way, the rights and freedoms of minorities will always be at risk if left solely to the mercy of an ascendant majority. The very fact that judges are unelected will ensure that they are free from majoritarian pressures when they rule on the validity of legislation. So, the idea here is that democracy is something more substantive and richer than simply the majority getting its way all the time. Democracy includes not just majority will, but also the protection of certain basic rights which would ensure that the core interests of non-majorities are safeguarded. And obviously, if that is to happen, then a body which is not subject to the pressures of elections, which isn't responsive to majorities, must have the task of protecting those rights. And that is the reason why a judiciary is entrusted with that task. These are basically the arguments of both the proponents and the critics of judicial review. Now, before we move on, some interesting facts. One is that despite many of its important former colonies having bills of rights, the US, South Africa, India, Canada, England still lacks a constitutional bill of rights. That's one interesting fact. And another interesting fact to ponder over is that Justice Felix Frankfurter, one of the American Supreme Court judges, a very influential and famous judge, was also one of the most influential experts that the drafters of the Indian Constitution consulted while framing their Bill of Rights, which only goes to show that comparative constitutional law is nothing new. It has been in vogue and in practice for a long time. In fact, it goes back to the inception and the origins of our own Indian Constitution. Let's now come to some of the core issues surrounding Bills of Rights. And the first is a distinction between what is known in scholarship as vertical rights and horizontal rights. Now, if you go back to the American Constitution and the origins of constitutionalism, the original objective of a Bill of Rights was to set limits upon state power and protect individuals from the prospect of state tyranny. Thus, the very first amendment of the American Constitution is framed as a prohibition upon state action. It says, Congress shall make no law abridging the freedom of speech, and it goes on. In constitutional language, these are known as vertical rights, that is, rights granted to individuals against the state. As we discussed earlier, the basic idea is that there are limits upon what the sovereign can do to individuals under his jurisdiction, and that's at the heart of constitutions and bills of rights. On the other hand, in the 20th century, decolonization and other liberation struggles often involved combating not just foreign or oppressive power, but inequalities and injustices within society. In India, for example, as we are all aware, the caste system and untouchability was a major social blight during the colonial period and before and after. And this was a problem that wasn't connected to the British colonial state infringing upon people's rights. This was a problem which was connected to certain segments of society oppressing others. And aspects like these and events like these led to certain constitutions enshrining what are called horizontal rights within the Bill of Rights. That is, rights guaranteed to individuals against the acts of other individuals or the acts of other groups. That is to say, horizontal rights are not applicable against the state, but against other private entities. To take examples of horizontal rights, one is Article 17 of the Indian Constitution, which prohibits the practice of untouchability, which had long been a scourge of Indian society and makes it punishable. Similarly, Article 15, Clause 2 directly attacks the caste system and other pernicious practices of social boycott that were prevalent in the Indian society by requiring that no citizen shall be denied access to shops, public restaurants, hotels, and places of public entertainment only on the grounds of religion, race, caste, sex, or place of birth. And as you can obviously see, the idea behind this is to prevent various practices of social boycott and the caste system that were implemented by individuals and groups against other groups and did not involve the state infringing upon individual liberty. And India is not the only constitution that has horizontal rights. Section 8, Clause 2 of the South African Constitution provides that the provisions of the Bill of Rights will bind a natural or juristic person if that would be applicable, taking into account the nature of the rights and duties it imposes. So unlike the Indian Constitution that has specific horizontal rights, South Africa's Bill of Rights makes it clear that all its individual rights could be applicable horizontally depending upon context. And this is a major advance. It marks the wheel coming full circle from the original American Constitution, which only envisages vertical rights, to South African, which is a very recent constitution, 1994, which envisages all rights potentially being applicable horizontally. While the text of the constitution does say that, the South African Constitutional Court judges have nonetheless been a little hesitant about using it that way. So what they've done more often is something that in scholarship is called indirect horizontal application, which means that instead of directly requiring individual parties to abide by the substantive provisions of the Bill of Rights, the court will interpret existing common law or existing private law in a way that brings it into conformity with the Bill of Rights. sometimes the court will go so far as to strike down or substantially modify common law rules in order to achieve its goal. One interesting example of this is the South African case of Khumalo versus Holomisa, which is sometimes considered to be a horizontal application case. In that case, the court held that the common law of defamation would have to be brought into conformity with the constitutionally guaranteed right of freedom of speech and expression. Now, as we know, the common law of defamation has certain aspects which broadly are called strict liability aspects, which means that if you make a defamatory statement which you can't prove to be true or certain other defenses, then and if that statement lowers the reputation of the target subject of the statement in society, then you are liable for defamation, and it is no defense to say that you took due care in making that statement. And this of course would mean that, especially in the context of the press and newspapers, that it's possible to use the law as a tool to silence speech by chilling newspapers into silence. And recognizing that aspect, South African courts have held that therefore defamation law must be changed and modified so as to ensure that it's compatible with free speech and expression. And they've done so by, for example, modifying strict liability rules and introducing requirements of reasonableness, which the prosecution must prove, or the plaintiff, must prove before a claim for damages is sustained. Similarly, the German court does not treat its Bill of Rights, which are embodied in its what's called its basic law, which is its constitution, simply as entitlements of individuals against the state, but also as embodying what they call an objective order of values, which the court must keep in mind while interpreting legislation. And that's another aspect in which you can see in which horizontal rights are applied indirectly between individual parties. Furthermore, there are also aspects where constitutions do not specifically mention horizontal rights, but courts read in horizontal rights into the constitution in an implied way. And one important jurisdiction that has done it is India. India has developed a judicially created set of horizontally enforced rights. The most important of these rights is the right to privacy, which the court has read into Article 21's guarantee of life and personal liberty. In the 70s and 80s, the court held that there existed a constitutional right to privacy implicit in Article 21 against state surveillance of the individual. But in the 90s and into the last decade, through a series of cases such as Mr. X versus Hospital Z and Rajagopal versus State of Tamil Nadu, the court has held that the constitutional right of privacy applies to the relationship between private parties as well. In Rajagopal, for instance, the court injuncted the publication of a supposed autobiography of a notorious incarcerated criminal on the ground that such publication, without his consent, would violate his right to privacy. In adjudicating these cases, the courts have broadly followed a proportionality test. They have attempted to balance the public interest, if any, in the disclosure against the claimant's right to privacy. Now, that is as far as the controversy over horizontal and vertical rights goes. Our next topic is what we broadly call rights and obligations, and here it's closely connected with the idea of horizontal and vertical rights. Again, recall that classically, rights in a Bill of Rights are enforced against the state. That begs the question, what is the state? And specifically, more in recent times, with the retreat of the welfare state in many jurisdictions and the control over functions that originally vested in the state passing into private hands, the understanding of what a state is and what it is supposed to do is constantly changing. Consequently, it is arguable that instead of understanding bills of rights as guaranteeing individual protection against exercise of power by the state, they should be construed as guaranteeing protection against state-like power, even if the entity exercising that power is private. For example, we think of the police force or prisons as being classically maintained by the state. Or for example, we think of foreign affairs or defense, or in other countries the provision of basic necessities like say water or roads as being state functions. But if, for example, the state would outsource the maintenance of roads to private parties, if the state would outsource police functions or maintaining prisons, as it is doing in countries like the US and the UK, to private parties, it would seem somewhat illogical and counterintuitive if the scope of Bill of Rights would correspondingly be narrowed simply because the state is abdicating its traditional functions. If that was true, then the state could simply get around the obligation of adhering to individual rights by outsourcing its functions to private parties. And that would lead to a situation where potentially, in a wholly privatized state, people would have no rights against any entity because the state is performing no functions. And that conclusion clearly is somewhat problematic, which is why the argument is that ultimately what is crucial is not the entity which is exercising power, but the power itself and what the power is about. And one good example of this approach is found in the American constitutional case of Marsh versus Alabama. In that case, what happened was that a private entity was controlling a company town, which means that the various mines and other such things in the US, and often because they were very labor intensive, people would move to or near those mines and live in communities which would be maintained by private companies who were responsible for exploiting those mines. These are called company towns. Now in Marsh versus Alabama, there was a company town like this, controlled by a private party, and that private company forbade an individual from carrying out religious preaching on a sidewalk that was otherwise open to the public. The American Supreme Court held that the private company's functions closely resembled that of the state, which is this function of the city municipality in maintaining a town, and that consequently the private company was subject to the Bill of Rights, just like the city municipality and organ of state would have been. The court's focus, therefore, was not on the fact that a private company was maintaining the town and therefore would not be subject to the Bill of Rights, but that the maintaining of a town is itself a public or a state function, and therefore no matter who maintains it, private or public party, a Bill of Rights would apply to that geographical area or that function because the function is public. The idea that private entities perform public functions and should therefore be subject to bills of rights is still in the process of development, and the position of law across jurisdictions is still being constituted. In India, one case that directly addresses this question is Justice Mohan's concurring opinion in the case of Anju Krishnan versus Andhra Pradesh, a right to education case before the new act. According to Justice Mohan, education being a quintessentially public function, even private institutions engaged in imparting education would have to adhere to the obligations of fairness and non-arbitrariness contained in Article 14 of the Constitution. Now, of course, the issue of what constitutes a state function and where we draw the line between state and non-state is itself controversial, and there is no one right answer. But it's an issue that bears thinking about going forward specifically. The next distinction that constitutions and bills of rights draw is between what are known as civil, political, and socio-economic rights. Substantively, one of the major debates about the content of bills of rights has been whether it should include only civil and political, or in other words, negative rights, such as the freedom of speech and expression, the right to life and personal liberty, the right to equal protection of laws, etc., or whether it should also include socio-economic, positive rights such as the right to health, the right to food, the right to work, the right to education, and so on. Conceptually, the distinction between the two is thought to lie in the fact that negative rights only require the government to abstain from interfering with an individual's liberty, while positive rights require the government to take active action to provide goods and services to individuals. Closely linked with this idea is the idea that the implementation of positive rights require the government to take decisions about policy and budgetary allocation, which a court is ill equipped to adjudicate upon, since such decisions require a kind of economic and financial balancing that lies within the competence and legitimacy of the government. This distinction, however, has been criticized as being incoherent. It is argued that so-called negative rights involve as much governmental action as positive rights. The right to property, for instance, is meaningless without an institutional system that involves a police force to prevent trespassing and a legal structure to punish it when it does happen. Similarly, the right to vote, a negative right, is meaningless without a system of voting, a system of electronic voting machines or manual voting machines, police guarding voting booths, poll officials and so on, each of which requires budgetary allocation, finance and money, and that therefore that distinction is somewhat incoherent. It's also been argued that positive rights are inherently vague and open-ended and therefore only fit for resolution through the political process. This objection, however, fails for reasons of under-inclusiveness and over-inclusiveness. Public interest limitations on negative rights found in constitutions all over the world, including the Indian, are as open-ended as positive rights. On the other hand, the UNESCR's General Comment 12 on the right to food is the very model of clarity and precision in its definition of the right. It states, "The availability of food in a quantity and quality sufficient to satisfy the dietary needs of individuals, free from adverse circumstances and substances, and acceptable within a given culture." Now, at the time of the framing of the Indian Constitution, civil, political and socio-economic rights were distinguished sharply. Civil and political rights were placed within the Bill of Rights, while socio-economic rights were placed within the non-enforceable chapter of the Constitution called Directive Principles of State Policy, borrowed from the Constitution of Ireland. Over the years, however, the Indian Supreme Court has blurred the distinction by reading in the directive principles into both the meanings of fundamental rights, such as the right to equality of opportunity, as well as into the restrictions upon various rights, in judging, for example, when a particular restriction is reasonable. In addition, even the Parliament has followed suit. For example, the right to education, which was originally placed within the Directive Principles chapter, was ultimately brought within the Bill of Rights via a constitutional amendment. The right to healthcare, to housing and to education, for example, are all expressly guaranteed by a South African Bill of Rights. At the same time, however, that Bill of Rights also allows the government to undertake a progressive realization of those rights. In practice, this means that the court will not require the government to immediately provide a particular good or service, that is, a specific medicine or a house. Rather, the government will need to demonstrate that it is taking reasonable steps to create institutions and structures that will ensure the adequate fulfillment of the right in question. South African cases have also opined that there is a greater burden upon the government to ensure the fulfillment of the minimum core of the right in question, especially where the most vulnerable groups are concerned. For example, in the case of root boom, the court held, the government measures must establish a coherent public housing program directed towards the progressive realization of the rights of access to adequate housing within the state's available means. The program must be capable of facilitating the realization of that right. The precise contours and content of the measures to be adopted are primarily a matter for the legislature and the executive. They must, however, ensure that the measures that they adopt are reasonable. In any challenge based on Section 26, in which it is argued that the state has failed to meet the obligations imposed upon it by Section 26(2), the question will be whether the legislative and other measures taken by the state are reasonable. A court considering reasonableness will not inquire whether other more desirable or favorable measures could have been adopted or whether public money could have been better spent. The question would be whether the measures that have been adopted are reasonable. It is necessary to recognize that a wide range of possible measures could be adopted by the state to meet its obligations. Many of these would meet the requirements of reasonableness. once it is shown that the measures do so, this requirement is met. That's how the South African court understands positive rights, socio-economic rights, and the idea of progressive realization. Our last topic in this module is interpreting bills of rights. Now, there are two dominant approaches to interpretation. These may be called broadly originalist interpretation and the living tree interpretation. Originalism, in its most popular variant, holds that the meaning and scope of rights must be fixed on the basis of the meaning that they carried at the time of the framing of the Constitution. The living tree philosophy, on the other hand, holds that the court should change and modify the scope of rights based on evolving circumstances. The controversy came to a head most famously in the American case of Brown versus Board of Education, where the Supreme Court overturned its own precedent to hold that the equal protection of laws guaranteed by the American Constitution did not allow the segregation of races, even though at the time the 14th Amendment, the source of the guarantee, was drafted, segregation was a widely accepted practice. In India, an interesting example of evolving interpretation, the living tree, may be found in the judgment of the Delhi High Court in Nas Foundation versus NCT, where the court held that the word sex as the ground of discrimination prohibited under Article 15 also included sexual orientation, and therefore, insofar as Section 377 of the Indian Penal Code outlawed homosexuality, it was invalid and unconstitutional. Closely connected with this debate is also a debate about whether the court should restrain itself to rights expressly guaranteed by the constitutional text, or whether it can read in rights via implication. One interesting example is the right to privacy. Some constitutions, like the European Convention on Human Rights and the German Basic Law, have an express guarantee protecting privacy and private life as a fundamental right. Other constitutions, as the American and the Indian, do not have this right, perhaps because when they were being framed, the right to privacy wasn't a major concern. Over the years, however, with the increase in state surveillance and otherwise, privacy has come to the forefront of the constitutional discourse. Courts in the US and in India have therefore read in the right of privacy into the Bill of Rights. The Indian Supreme Court has done so by holding that privacy is an aspect of the right to personal liberty guaranteed by the Article 21 of the Constitution. Let's now conclude. Bills of rights have become staple features of modern constitutions and have been at the forefront of some of the most important and far-reaching social and political controversies of the age. As we have seen from the above discussion, issues of freedom of expression, personal privacy, abortion, public health, education, and housing are all notable either because they are directly addressed by a constitution, a Bill of Rights, or because the Bill of Rights fails to address them, and it becomes the task of the court to deal with them. It is clear that to a large extent, what our societies will look in the future shall, to a significant extent, be shaped by bills of rights and the contestation around the interpretation. Thank you.